English for international trade. Strategic business English for navigating laws, mechanisms, and agreements. Welcome to this resource on business English for international trade, developed by Marc Roche and Macson Coaching. This one-page mini-course has been developed as part of our self-study program, Strategic Business English, Leadership and Management, available exclusively through Amazon. For more free resources, visit www.macsonbell.com. Listen to each of the sections in this mini-audio course and complete the downloadable comprehension and vocabulary exercises available from www.macsonbell.com. Navigating International Trade in English, a journey through its history and principles. In the aftermath of World War II, the global landscape underwent a profound transformation, not least in international commerce. The year 1947 marked the dawn of a new era with the introduction of the General Agreement on Tariffs and Trade, GATT, a pivotal moment that set the stage for the trade agreements we navigate today. GATT's primary mission was simple yet ambitious: to dismantle trade barriers and ensure fair treatment for all in the international marketplace. As the decades unfolded, the terrain of international trade expanded. It evolved from GATT to the establishment of the World Trade Organization, WTO, in 1995. The WTO broadened the horizons beyond mere goods to encompass services and intellectual property, positioning itself as the cornerstone of global trade governance and dispute resolution. The evolution of trade agreements mirrored this growth, transitioning from straightforward bilateral pacts to multilateral frameworks. The emergence of regional trade alliances like the European Union, NAFTA, now rebranded as USMCA, and ASEAN highlighted a trend towards economic integration, reflecting the dynamic nature of international trade law and its ability to adapt to the multifaceted challenges of digital commerce, environmental sustainability, and globalization. For legal experts and international businesses, a deep understanding of this historical journey is not just academic, it's a vital navigational tool in today's complex trade environment. Unpacking the principles. To grasp the essence of these principles, consider the role they play in everyday international transactions. For instance, the MFN treatment ensures that no country is left at a disadvantage in trade agreements. National treatment and transparency work hand in hand to create a trading environment where all goods compete fairly and information is readily available. Meanwhile, trade liberalization and fair competition encourage innovation and efficiency, driving economies forward. Lastly, the focus on economic development and reform highlights the global community's commitment to inclusivity and support for all nations' growth trajectories. Understanding these principles isn't just about legal compliance or business strategy, it's about contributing to a global economy that values fairness, transparency, and mutual benefit. As we navigate the complex currents of international trade, the history and principles serve as both a map and compass, guiding us towards a future of prosperous and equitable commerce. Major sources of international trade law. International trade law is derived from a variety of sources, the most significant of which include international treaties and conventions. These are formal agreements establishing trade rules between countries. Key examples include the General Agreement on Tariffs and Trade, GATT, the General Agreement on Trade in Services, GATS, and the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, all guided by the World Trade Organization, WTO. Customs law. Each country has its own set of customs laws regulating the import and export of goods. These laws include tariff regulations, trade classifications, valuation, and duty reliefs. Bilateral and multilateral agreements. These agreements between two or more countries can supplement global trade rules with more specific or different terms. Examples include free trade agreements, FTAs, and regional trade agreements, RTAs. National laws and regulations. Domestic legislation of individual countries also plays a crucial role in governing international trade. These laws must align with international commitments, but can vary significantly in their specifics. Case law and judicial decisions. Decisions made by courts, especially those in international tribunals like the WTO dispute settlement body, serve as important references for interpreting and applying trade laws. Imports and exports. Import and export laws constitute a crucial part of international business and trade, governing the movement of goods and services across national borders. These laws are designed to control which goods may enter or leave a country, ensure the collection of appropriate taxes and duties, and comply with various international agreements and national security protocols. They often vary significantly from country to country, reflecting each nation's economic policies, political relationships, and public health and safety standards. Licensing, tariffs, and duties. Licensing. Many countries require specific licenses for importing or exporting certain goods. These licenses are crucial in regulating trade in sensitive commodities, such as arms, certain chemicals, pharmaceuticals, and wildlife products. Licensing ensures that trade in these goods is monitored and conducted responsibly. Tariffs. Taxes imposed on imported goods. They serve multiple purposes, raising government revenue, protecting domestic industries from foreign competition, and sometimes retaliating in trade disputes. Tariffs can be specific, a fixed fee per unit, or ad valorem, a percentage of the value of the goods. Duties. Import duties are levied to regulate the flow of goods into a country. Though less common, export duties are imposed on goods leaving a country. Duties are often used to control the balance of trade and protect local industries from overseas competition. Trade agreements. Trade agreements are key instruments that shape international commerce, establishing the rules for trade between countries. There are three broad types. 1. Bilateral agreements. These are trade agreements between two countries. They typically reduce tariffs and trade barriers, facilitating increased trade and economic cooperation between the two nations. An example is the United States-Korea Free Trade Agreement, KORUS. 2. Multilateral agreements. These involve three or more countries agreeing to trade terms. Such agreements often address complex global trade issues and require lengthy negotiations. The World Trade Organization, WTO, is a perfect example of a multilateral trade organization encompassing numerous agreements. 3. Regional agreements. These are made between countries within a specific geographical region to foster economic integration. They can lead to the formation of regional trade blocs. The European Union, EU, and the North American Free Trade Agreement, NAFTA, now succeeded by the United States-Mexico-Canada Agreement, USMCA, are prominent examples. Major trade agreements. NAFTA and USMCA. The NAFTA agreement, replaced by USMCA, significantly changed North American trade dynamics, eliminating most tariffs between the US, Canada, and Mexico, and creating one of the world's largest free trade zones. European Union, EU. The EU is not just a trade agreement, but a unique economic and political union between 27 European countries, featuring its internal single market with standardized laws and free movement of goods, services, capital, and labor. Association of Southeast Asian Nations, ASEAN. This regional grouping fosters economic, political, and security cooperation among Southeast Asian nations, promoting free trade and economic integration in the region. Impact of trade agreements on global trade patterns. Trade agreements significantly impact global trade patterns. They can increase trade flows, economic growth, and cross-border investments between member countries. Limiting or eliminating tariffs and other trade barriers makes goods and services cheaper and more accessible, benefiting consumers. However, they can also lead to trade diversion, where trade is redirected from more efficient exporters towards less efficient ones within the trade blocs. Furthermore, the complexities of negotiating and maintaining these agreements often require a delicate balance of political, economic, and social interests. Customs regulations. Role of customs in international trade. Customs authorities are pivotal in international trade, acting as the gatekeepers at each country's borders. They are responsible for regulating the flow of goods into and out of a country, ensuring compliance with national and international trade laws. This includes enforcing import and export restrictions, collecting tariffs, and preventing illegal trade. Customs procedures are essential for protecting a country's economic interests, security, and public health, while facilitating legitimate trade and commerce. Customs valuation and classification. Valuation. Customs valuation determines the value of imported goods to levy tariffs. This typically involves the transaction value method, where duties are assessed based on the price paid or payable for the goods. Other methods may be used if the transaction value is not available or acceptable under customs regulations. Classification. Goods must be accurately classified according to a standardized system, such as the Harmonized System, HS, of tariff nomenclature. Correct classification is crucial as it determines the duty rate and eligibility for trade preferences or restrictions. Enforcement of customs laws and penalties for non-compliance. Customs authorities enforce trade laws to prevent illegal activities such as smuggling, fraud, and intellectual property violations. Non-compliance with customs regulations can result in serious penalties, including fines, confiscation of goods, and legal prosecution. In serious cases, it can lead to trade sanctions against businesses or individuals. Compliance requires a thorough understanding of customs regulations and accurate documentation and reporting. Mechanisms for resolving trade disputes. Resolving disputes in international trade is crucial for maintaining harmonious commercial relations between countries. The mechanisms for dispute resolution vary, but typically include the following. 1. Negotiation. The first and most straightforward approach involves direct negotiations between the disputing parties. This method is often preferred for its flexibility and potential for preserving business relationships. 2. Mediation. If negotiations stall, mediation can be employed. A neutral third party helps the parties in a dispute find a mutually acceptable solution. Mediation is non-binding and focuses on facilitating dialogue and understanding. 3. Arbitration is where the disputing parties present their case to an independent arbitrator or panel. It is a more formal process, and the arbitrator's decision is usually binding and enforceable in court. 4. Litigation. When other methods fail, parties may resort to litigation, taking their dispute to a national court or an international tribunal. This process is often lengthy and costly. The role of organizations like the World Trade Organization, WTO, in dispute resolution. The World Trade Organization, or WTO, plays a pivotal role in the orchestration of international commerce, acting as the principal arbitrator in global trade disputes. Established to oversee and liberalize international trade, the WTO embodies the core of modern economic diplomacy, navigating the complexities of trade relations among its 164 member states. Central to the WTO's dispute resolution mechanism is the Dispute Settlement Body, known as the DSB. This forum is where trade disagreements are analyzed, providing a structured environment for member states to resolve conflicts arising from the interpretation and application of WTO agreements. The mechanism starts with formal consultations aimed at reaching a mutual understanding. If these consultations do not yield a resolution, the dispute can escalate to a panel review where a detailed examination of the case takes place, culminating in a report that can be adopted as the DSB's ruling. What sets the WTO's dispute settlement mechanism apart is its binding nature. Adherence to the rulings is not optional, ensuring that decisions have real-world implications. This could include the authorization of countermeasures, such as trade sanctions, against a country found in violation of the agreements. Such enforcement underscores the seriousness with which the WTO's rules are implemented and respected globally. Despite playing a crucial role in keeping the international trading system stable, the World Trade Organization's method for solving disputes has faced criticism. Critics argue that the process is complex, slow, and can be affected by political pressures. These concerns highlight the continuous debate on international trade and underline the importance of ongoing reforms to address the changing needs of global commerce. In conclusion, the dispute settlement body of the WTO exemplifies the delicate balance between legal arbitration and diplomatic negotiation in the realm of international trade. As future leaders in the business world, understanding the dynamics of such institutions is crucial for navigating the complexities of global trade relations. The WTO, with its comprehensive approach to dispute resolution, remains a cornerstone of international economic governance, ensuring that trade continues to flow as freely and fairly as possible across borders. This is a one-page mini-course module from the Strategic Business English Leadership and Management Self-Study Program by Macson Coaching, available exclusively from Amazon. For more free resources, visit www.macsonbell.com.